The Foreign Corrupt Practices Act is a United States law that has been in effect since 1977 that makes it a crime, a federal crime under U.S. law, for any individual or any company to corruptly pay any bribes or anything of value to any foreign officials, directly or indirectly, for the purpose of obtaining or retaining contracts or for the purpose of gaining any business advantage whatsoever. It carries serious penalties, including possible prison terms for individuals and also significant fines and disgorgement penalties for companies, depending upon the circumstances. There's a second provision we'll talk about in a later blog. That provision is known as the accounting provision. That provision requires that any and all publicly traded companies maintain records, financial records of any and all of its financial transactions, which would permit investigators to examine those. We'll talk about that later because it's a good idea for all companies, even companies that are not publicly traded, to have such accounting provisions available. Every company who is subject to the Foreign Corrupt Practices Act in the U.S. should have a compliance program. Not just a compliance program on paper, but a very real, robust compliance program with policies, procedures, rules, reporting requirements, reporting paths, with a compliance officer, and with significant training to make sure that it's legitimate and very, very real. Sadly and unfortunately, it's estimated that about half of all U.S. companies that are subject to the FCPA don't have any such compliance programs whatsoever, and that makes them very, very vulnerable. It's also just as important that any company or any individuals doing business overseas, before you engage any third party or agent or anyone like that, even though those individuals may not be, and certainly shouldn't be, government officials, that due diligence investigations are conducted to ensure that any payments made to those individuals are not destined for or do not go to public officials in those countries. It's also important to note that while the U.S. led the world with the FCPA, most countries in the world, certainly all developed countries, and most countries now involved in international trade, have similar laws that your country will be subject to in dealing with or in those countries. It's finally very, very important that you maintain training for all of your employees, all of your officers, all of your agents, and any third parties you deal with, and make certain that any and all violations, whether they're suspected or confirmed, are immediately reported to your compliance officer so that intelligent decisions can be made with your counsel about whether those need to be reported or not. We'll talk about some of the other provisions we mentioned in coming blogs. Thank you.